Welcome to another edition of the Litigation Psychology Podcast brought to you by Courtroom Sciences. Dr. Bill Kanasky here with a dear friend, special guest. All my guests are special, but this one's really special, and he's been on before. Trial attorney from Fort Worth, Texas, where I'm sure it's hot as hell right about now, just like it here is in Florida, Mr. Shane Odell. Shane, what's going on, baby?
Not much, Bill. Thanks for having me. And it is, I can confirm it's hot. I was at a golf tournament with my son on Sunday, and it was 103 heat index. So it's already full blown summer here.
Oh gosh, that's crazy. Now, how old is your son?
He just turned 14.
Okay, so now difference, like when I was growing up, we were poor and I played sports that didn't cost a lot of money because we didn't have a lot of money. I just what's the annual dad contribution towards a 14-year-old with a golf hobby? This cannot be cheap.
No, it's steep. And the problem is as
equipment,
they grow, yeah,
as
they grow, you got to get new clubs over and over. He had 2 different sets of clubs last year for
he's growing. He's 14.
Yeah.
So I say what, every 6 to 12 months? I mean, wow.
Yeah, luckily now he's at a place where he's playing adult clubs, like full-size men's clubs. And so the changes will be more limited on the equipment side, but yeah, access to the course, a range, coaches. I mean, he's got coaches that are at the course that we're at. He's got coaches at other places. It's
our kids got it too good to this. They got too good. They got too good.
Sure.
So you tell your kid, remember, you always be nice to your kids because you're going to tell them, oh, by the way, when I'm old, you're taking care. That's why I'm taking care of you. So you're going to take care of me, 40, 50 years from now, right?
That's right. He broke his wrist in the fall, and so he had a long break from it. And I was worried that he would either, he would hate that he had this break, or maybe he wasn't as interested in playing anymore. But he's come back with a vengeance. I think it reminded him how much he enjoys it. So
that's awesome. That is incredible. Well, good for him. I just sent you pictures on your phone of my upgraded man cave and personal home gym. We have not discussed what. Just let the audience know. As good as advertised?
That's a full-blown gym. It's got the Carolina blue.
Oh, yeah.
You've got the banners hung. Did you retire your own jersey in there?
I ain't get not my own jersey yet, but I got the 7 banners up there. Yeah.
You have everything. It's decked out, even with the Smith Center seats.
You got the original Smith Center seats.
Man, that's
when
legit.
they remodeled. So so we're going good on the man cave. So I needed independent verification that it was pretty cool.
Yeah, that's awesome.
Yeah, I think I may start charging membership fees to my family and my kids' friends that come over because now everybody wants to use it. It's mine.
Yeah, I can see that. I
know.
Probably get a pretty penny for that.
Yeah, exactly. Right. Okay. Well, we have a couple things to talk about today. What I want to start doing more of on the podcast is talk about cases that have gone to trial, and regardless of outcome. I mean, no one wants to talk about losses, but you should still talk about losses, particularly positive outcomes. Kind of, for the audience, you had a recent case, went to trial. I would love you to kind of summarize the case, kind of, what some of the challenges were, what you were up against. And then we can talk a little bit about how I helped you out as far as the narrative and the storytelling model for the opening. But I think we need to start doing more of this because, again, you may not be going to trial a lot, but to get stories from trial and to learn, I think is incredible. So why don't you go ahead and kind of summarize the case and kind of what you're going up against there.
Okay, so yeah, it was a little bit of a unique case for us because we do a lot of commercial, a lot of product liability. This was an individual homeowner, and she had hired someone to replace water heaters in her attic. And I have a bad habit of saying hot water heaters, and my wife has corrected me for years saying
it's
not a hot water heater. The water's not hot.
It's a redundancy thing, right?
Yeah. So she hired a contractor that she had some experience with to replace water heaters in her attic. And he went and he picked up an assistant, a helper, in a parking lot to help him with this project. And that assistant fell through the attic floor while they were moving the water heaters. 38 feet, I think 37 feet down to the
Wow.
top floor and broke both arms. Rushed to the hospital and was in a cast on both arms for 6 months and is unable to work and do manual labor now.
Well, let's pause there. So he was picked up in a parking lot.
That's right.
Okay. Now, maybe that's a Texas thing. Yeah, it could be. But also, I think the bigger question is what, not the hot water heater, the water heater. I know we talked about this earlier during this case. Mine's in my garage. Mine's always been in my garage. Why is the water heater in the attic?
That's a great question. It's pretty common here in Texas to have maybe one or two, and there was a period of time where houses were being built, 90s, 2000s, where it's actually really common to have them both upstairs. It's easier to plumb that way, I suppose, but it's very common. And that was actually part of our voir dire in the case was, does anyone have water heater in their attic? Does anyone have a fully decked attic? Because there were all kinds of contentions about whether it was decked or undecked.
Yeah.
So, getting that kind of understanding and kind of collaboration with the potential jurors was important.
Okay. So tell us about your client and what were the claims?
So the client was fantastic. She's an amazing lady. She works in the healthcare industry. She made a really good witness. Sometimes you have witnesses that are just not great. She was instinctively good at pushing back when she needed to and not fighting things that she didn't. I mean, she was really the star of the trial. She really knew how to handle herself and was very intelligent and knew exactly when to elaborate and when to not.
Okay. Now, did you have expert? Tell me about the experts. Experts, because this seems to be a unique case. I mean, I until you called, I can't say in 23 years I had worked on a water heater case falling 38 feet through several floors. That was not on my bingo card.
Yeah, so the the experts, this was part of the interesting thing about this case. Really skilled plaintiff lawyer on the other side. We get along really well. Still talk and swap text messages. We had there was a third party involved on the medical side that really made it impossible for us to settle the case. And so
Really?
we knew that we were going to trial simply because we couldn't get them to play ball or be reasonable. And so, that really kind of changed the complexion of the case. Yeah, I go with sports analogies a lot. I know you do as well.
Absolutely.
It was kind of like going to trial against somebody who went for it on every fourth down,
Yeah.
ran a fake punt, fake field goals. I mean, he was throwing it all everything that he had at the case, and I respect that. At the same time, we had to be really on our toes. So we had medical billing experts about the charges and the costs and that kind of stuff at the pretrial, the day of and day before jury selection. He non-suited all of those claims and just tried the case on non-economic damages, mental anguish, pain and suffering.
Pretty common.
And so, well, we've seen that a lot on
Yeah.
lower medical cases. This was not a lower medical case, as you can imagine, too. Surgery on your arms in cast for 6 months. The medical was well over $100,000. And so we're seeing more and more now in Texas where even the bigger medical numbers are being non-suited to prevent there from being an anchor on the medical.
Everything's big in Texas, Shane.
That's right. That's right.
All right. So you figure out you're going to trial, and you and I had talked beforehand. Why don't you kind of start? Because I do so much consulting, on opening statement construction because I see a lot of issues with this for deer as well, and I think that they're intimately connected. But having a good story, having a really good narrative, not telling your story in the wrong way, that's a big thing with me. And what we've seen, God, over the years is that the story that may come from you and your heart and what you think is the right story may not be the right story. And you can tell a story, a number of different ways. And I also think that I think it's very difficult for any attorney, plaintiff or defense, is when you, I mean, how long did you have this case before trial?
This case was on around almost 3 years before we tried.
So 3 years, you can kind of get blinded, right, by your own confirmation bias, and you're working up this case, working up this case, and you think you got the story, and maybe you don't have a story. So why don't you kind of talk about the original story and kind of how you first envisioned sharing this with the jury?
Yeah, so because our client was such a strong witness and a really great personality, I thought that we would feature her in the opening and start the conversation with trying to relate to the jurors. One of our voir dire questions was, are you a homeowner or do you live in an apartment?
Yeah,
You know, have you been in an attic before? Have you ever hired someone to replace a water heater? Ever hired a contractor? Those kind of questions.
sure.
A lot of things that we asked about were, oh, well, I assume if something happens on my property, I'm automatically responsible for it, which
Yep.
is not what the law
Yeah,
says. So
everybody
a
thinks
lot of
that.
everybody thinks that. And so
Like
we had,
if you rear end somebody in an auto accident,
right,
you're automatically at fault. That's not how it works.
that's right. And so I've heard you say this before, but if you want to find the problem, you have to address it.
Yep.
And so that's what we had to do was figure out. And I think that was one of the biggest issues in the case was homeowners believe that if something happens on your property, and other people believe that if something happens on someone else's property, they're automatically responsible for it. So we asked about it and we dug around in voir dire about it. So then we were going to dovetail the opening and really feature our client and talk about her and how great she is, but really focusing on that midway through the opening and going with, she hired a contractor who she trusted to do this. She delegated that to him and she should be able to go to work and do the things she needs to do and not worry about what happens while they're performing this task at her home. But when I talked to you, and this was kind of reframing it and trying to use your flashback formula to,
Yeah.
start from the time when the water heater, or when we're going to start from the time when she got home from work that day and there was a hole in the ceiling. And
Yeah.
then we were walk backwards from there. And I still did that in opening, but I didn't do it out of the gate. Because after talking to you, we really focused on shifting that cognitive lens, really
Yeah.
focus the case. And I did my opening from the perspective of the contractor to start. And then from the perspective of the plaintiff who was picked up in the parking lot of a Home Depot to do this one-off project.
Yeah.
And so that's where we started. And I thought the opening went extraordinarily well. I think it really set the stage and it made our client seem like it was just a matter of circumstances that had happened at her house, that if something bad was going to happen because of the circumstances, the choices that were made by the contractor and the choices that were made in other places, and it just so happened to occur at our client's home.
Yeah. And if you start the story with your client, it's your client's actions and judgments and decisions that are going to be judged most, right out of the gate. So by switching that up and starting your story at a different time point to put the key people you want to blame, you push them up first and leading with that, very, very wise. And then your client comes in after that. That's a very, very powerful way to do it. I've kind of seen it done the opposite way where it can really blow up in your face because you're like, hey, I want to talk about my client, this great person. The problem is when jurors get to your opening, they're like salivating for somebody or something to blame, And so like your heart tells you, I'm going to start off with my client. Well, that's the most time the jurors are most eager to blame somebody. So what you want to do is take your best stuff on alternative causation or somebody else in the case, you put that up front, you give them that. And then when you talk about your client, the jurors, their hunger for blame has been satisfied and you fed these two other people to them up front. Now, talk a little bit about the plaintiff's opening. What was that like?
The plaintiff's opening was factual. It was well done. He set out his theme. It was wrongs. It's the tip you see this plaintiff theme pretty consistently. It's about wrongs and how do we right wrongs, and this is the only way we have is to compensate people with money for things that happen to them. And so that was their opening. The openings were short.
How long was your opening?
I think it was 9 minutes.
That's what I'm talking about.
I think we had 15 minutes total. I think it was 9 or 10 minutes. Had time left on the table. I'm not sure if the plaintiff lawyer planned to do a long opening in this case. I don't believe that he did, but I've had other lawyers, when I say, "Oh, I only need 10 minutes for opening," kind of panic a little bit because they want to go on for a long time. And I think any more than 10 minutes and you're just talking to hear yourself talk.
Yeah, and so the general rule here, it really depends on the case, depends how many parties there are, right, and kind of how complicated the case is. You got that, I call it kind of like that 20 to 30 minute sweet spot where if you land in that interval, you're going to be in good shape. If you have a really, really straightforward case, and we've heard the plaintiffs on their podcast say this, plaintiff attorneys very actively advertising this. Hey, if I got a really straightforward case, I don't want to complicate things. I want to simplify things. And they're really good at simplifying things. So they're shooting for that, 10 to 15 minute mark, because if you do that, you can tell a solid story. It's very easy for jurors to follow along. It's almost impossible for them to get lost. And in 15 minutes, they can pretty much remember everything you said. You go up there and here's the problem. You have a plaintiff attorney that gets up there and does their opening in 15 minutes and it's razor sharp. And then defense counsel gets up there for 45 minutes or an hour. These people are not following that opening, period. It's done, number one. And that's just from a short-term memory and attention. But then you contrast it with, wait a second, this first person got up there and was razor sharp and was 14 minutes, right? Or 13 minutes or 15 minutes. And then defense counsel gets up and is all over the place for 47 minutes. Just the perceptual contrast to that is a real problem. Let me ask you just something about that between you and your colleagues at the firm. When you guys have meetings, is that something you've talked about as far as kind of a general strategy for the firm? Because I gotta tell you, I read one, I was hired, I had a weird example. Let me tell you about this. So last week I was hired by a current client who, and they're a new client. And we worked on several cases the last, I'd say, year, but they're a newer client. And they got rocked on a case like a year and a half ago. And so this client sent me the voir dire transcript and the opening statement transcripts and said, I'm going to pay you. I want you to just analyze what happened and tell me what happened. And Shane, the opening statement was not only was it just entirely too long. Now I had a transcript, but it seemed to be pushing almost an hour, right? Probably 55 minutes, which is way, way too long. And it had like no story. It was just all over the place. It was really impossible to jurors to follow. Do you guys at your firm talk about this stuff to say, hey, as a firm, we really need to be thinking, jurors have changed and we want to be more razor sharp and we want to get right to the point, because if we go long, it can create a bunch of jury problems.
Yeah, absolutely. We do. In fact, we're having a firm retreat in a couple of weeks. And our topics that will be discussed at our attorney meeting are 15-minute topics to try and get people to distill information. I'll tell you, I think one of the hardest things for anybody in this business to do is distill down a complex set of facts or an issues into as few words as possible and be efficient. It's easy to get up there and talk about everything. It's easy to tell them about the whole case, and everybody, including the plaintiff's shoe size, and you've got your client, everything about her and her family. But what's hard is to really be efficient and to get in and out and hit your points. That's what takes a lot of practice, and it takes a lot of experience, and it takes work.
It's let me tell you this, and I've worked with a number of defense counsel on this. And some plaintiff counsel, on the commercial side of things. The emotional discomfort of a 15-minute opening is no joke. I mean, I've had a lot of pushback. I can't tell this story. Like, I need 45. It's like, no, you don't. And if you need 45 minutes, you got a bad story. And to try to get an attorney to take a case and boil it down to a really solid 15-minute story, it's hard. It's really, really hard because jurors, when in an opening statement, you get into the weeds in an opening, you're going to lose people. I mean, you're just going to lose people. You got to stay in the clouds, right?
Right.
And that gets really, really hard because I think I've had defense counsel tell me that, like, I want to go an hour because I have this duty and obligation to my client to defend this case. I can't do that in 20 minutes. And I say to those folks, I'm like, now that's a defense mechanism right there, right? That's an emotional response. But the best way to defend your client in the case is to tell the best story, right? Not necessarily spend more time defending.
Right. No, I agree with you. I mean, you helped us on a case a year or two ago. It was 30-day trial,
Oh, I
commercial
remember.
litigation case. And I think I opened that case in 20 to 25. It was less than 25 minutes. And we were in trial for a month. You've got to pick your story, and then you hit like you said, you hit the highlights, you lay the groundwork. That doesn't mean when you get into your case in chief or into the witnesses, you can't branch out and go deeper. That's where you go deeper with each witness, and you start building your story for closing and plugging in the details.
And that's the key. Have most of these details come out through the witnesses, right?
It's almost like a movie trailer.
It is.
We're going to show you some of the highlights. We're going to tell you generally what you can expect, and we're going to get you to plug in and tune in to the rest of the trial and watch what we're going to do.
Yeah. So the cognitive lens, which if you listen to this podcast, you should know, this is pretty much the first 2 to 3 minutes of your opening, right? This is really what you're setting up your main characters, you're setting up your main storyline, and you're putting certain things in the spotlight and you're assigning blame immediately. Okay, that's the cognitive lens. By the way, Shane, every single movie trailer, every one of them, by design, is 2 to 2.5 minutes. Every one of them. And there's a reason for that, because that sets the stage, right? Right. Imagine if movie trailers were 15 minutes. You'd never get through it.
No.
You'd never get through it. You'd lose your mind. Right? So that's why you got that first couple minutes to really set the stage. And that's where I think most of this work can be done. And that's where I worked with you, because I'm like, listen, we got to get this first 2 minutes is everything. Right?
Right.
And then your last 2 minutes is pretty much a rewording of your first 2 minutes, right? Because you want to start and you want to end in the same spot, really, to make that the most powerful. And so that's a really, really good structure. And again, this case I analyzed for this client, I felt terrible. And by the way, this is a 30-year veteran defense counsel. And it was a terrible opening. It was really, really bad. And I don't think a lot of time, relative to other things that happen in litigation. I mean, think about it. How much billable time does your standard defense attorney have in opening statement construction annually? What percentage of your overall? It's 3?
Yeah, maybe.
Maybe?
Mean, if you're trying 5 to 7 cases a year, that's already a small percentage of what you're doing. And then you're doing opening only. That's really narrowed the scope. 3% might be an overestimate, but it's probably 3% or less.
Exactly. And another bad thing that happens is a lot of attorneys, they'll go back to an opening they did on a different case and kind of try to match that. So if you made mistakes there, they carry over, right? And so there's a better way to do this. There's a scientific way to do this. And you have my paper. Everybody's got my paper. I've talked about this on the podcast a million times. Did a bunch of CLEs on it, so you guys could look that up. So tell us about the outcome. Tell us about what it's like to wait for the verdict and all that stuff.
That's probably my least favorite part.
It's got to suck.
It's terrible. There's nothing you can do about it. It's all in the can. It's sent back, and you sit there and wait. The jury asked a question. So we came back, the court basically said, y'all go eat lunch. The jury was going to eat lunch and then start deliberating. They asked a question during lunch, which we didn't know that they were already deliberating. So we came back to the courthouse, got the question, answered that question, and then right after that, they had rendered a verdict. And it was a little surprising that they rendered it right after we answered the question. But it was a complete defense verdict. They didn't get to the damage question in the case. There was a great result for our client. I think something that is probably, I don't want to say underestimated or underappreciated, but the client, when she heard the verdict, just all the emotion of 3 years just let go. She started crying. She was
Yeah.
very emotional, couldn't have been more appreciative of our help. And I think a lot of times we forget about the toll emotionally that the cases take on the defendants, because the focus of the case is always on the emotion on the
No,
plaintiff.
no one talks. So I'm not sure if you listened or saw our recent podcast with attorney Larry Hall up in St. Louis. He ended with that, and we like I was like getting emotional on the podcast. He's like, yeah, like typically all the hugs and the tears are from the plaintiff's side. Like nobody talks about the defense, and he said it was a very very emotional, positive outcome, and that the defendants do have their people too, right? And they
Yeah,
tend to get
absolutely.
dehumanized in this process because it's all about the plaintiff, and that's not true. And so well, congratulations to you, your client. That's terrific. It's a great outcome, and I appreciate that breakdown.
I will
Now,
say too, on with Larry Hall, right before and during that discussion of the emotion, the passion that he has for his clients really was highlighted.
yeah,
And I love that he said they presented their case unapologetically.
yeah,
Jury can tell when you're sincere. They can
yeah,
tell. If you care for your client and you've been plugged into the case and you really feel strongly about, it's not just about zealously advocating for your client. It's believing in their position, knowing them as people and wanting a good result for them, and doing your best to try and get that. And I could not agree more with that. And the jury can feel it. They can tell it for sure.
outstanding.
So two quick things on this case. This, because of the going forward on fourth down and the trick plays, we had a pretty cooperative co-defendant. And so there were all kinds of issues with the co-defendant, obviously, and pointing fingers at him. And so we got to a place where we felt like we could, and they understood the strategy behind it. It wasn't something that we did without talking to
Yeah,
co-defendant, because I don't feel like I didn't want them to feel like we were cutting their legs out from under them unknowingly. But the focus of the case was on us because we had the money. And so it really
yeah,
ended up being something where we had to go after the co-defendant a bit. And the plaintiff lawyer, to his credit, was pretty wily. And in the middle of trial, right before the co-defendant was called to the stand, he non-suited him and then argued that we shouldn't get to have a blank on the charge for the co-defendant.
wow,
So I non-suited the medical at pretrial, non-suited the co-defendant after we'd pretty strongly pointed the finger at him about halfway through the case. And then our best cross-examination material on the plaintiff were lost wages, loss of earning capacity. He dropped those claims before the cross-examination of the plaintiff. And so all of that work, all the material that I was going to use in cross of the plaintiff went away. And so you have to be flexible. It was as much just being flexible and prepared as anything. And I think, it's just a world of, how do you pick and choose what to defend and where to go when the
yeah.
target's constantly moving?
Well, you were when you said fake punts and fake field goals and going on for you weren't joking. I mean, that's a lot of adjustment to be made
Yeah.
on your part. So, well, great work. Let's wrap this up with two other topics. Let's talk, something I know you're passionate about, and we talk a lot about in the podcast, is the training of and mentoring of younger attorneys. And we've seen one of the major obstacles to this is clients not wanting to finance that. Clients not wanting, you know, second and third chairs and stuff like that, or not at least not wanting to pay for it, and wanting you or one of your partners to do everything, and that doesn't help young attorneys. Can you talk about kind of your philosophy on training and mentoring, and how you talk to your clients to tell them how important that is? Because if your young people are not getting the experiences and the reps that they need, that they're not going to grow, and you can't really have your cake and eat it too when it comes to this stuff.
Yeah, no, it's critically important for us to obtain the experience for our young lawyers. The perspective they gain. I mean, you can work on cases all day long, but if you don't understand where it goes at the end of the day, and that a jury is going to make a decision based off of a bunch of questions on a charge, and those questions on the charge are formed by your pleadings, and then you get to introduce discovery and evidence and plug those pieces of the puzzle in. They're really only kind of practicing with half of the formula. If you don't let them see
Yeah.
how it goes at trial, then they don't ever think, how are we going to get this in? What are we going to do to try and get this in front of the jury? They see a good fact for us or a bad fact for the plaintiff, and they're like, oh, we're going to evaluate the case on this. Well, the question is it coming in? We don't know. We've got to do the work to see if it'll come in. If it will, great. If it won't, then we can't evaluate the case on something the jury will never hear, right?
Yeah.
And so obtaining that experience for them is critically important for a number of reasons, but that perspective is one of the huge reasons. And this client, to their credit, I wanted to take a young lawyer. I took one of my partners, Brad, Brad.
Yep.
We went down and tried the case, and the young lawyer watched, and he helped, and he got stuff ready, and he briefed things like the getting the blank on the charge for the co-defendant when they got non-suited.
Yeah.
They briefed a lot of that stuff, and he was really very helpful at trial. He definitely did not sit back and just watch and observe, but the client was on board. They were happy to have a young lawyer in there. They know the importance of investing in the future of the defense bar, and that's something that I think is extraordinarily important, is to see, the game being played. Right? I mean, you've got
Yeah.
to go to the game and watch it from the sidelines and get a little involved. Go out for the coin toss, go
Yeah.
on, play special teams a little bit, and
Yeah.
then you can come back and start getting more and more comfortable being more and more involved.
That's a really big deal. Now, as far as the firm, and kind of another issue that's popped up related to this is, young attorney retention. That's a big topic across firms. Is that part of your firm's philosophy to not just finding talent's one thing, keeping them's another, is to have mentorship and have training and that level of involvement as kind of one of the probably many carrots to keep people, because I think it's gut wrenching, and we've been through it here at Courtroom Sciences, and I know you guys have been through it. Is you invest a lot of time and money and effort into somebody, and then 2 years later they leave and go someplace else, and you're like, well, shit, what the, what
Yeah.
the? It's a real gut punch. What are some of the ways you guys work on just young attorney retention?
Yeah. So first off, I'll address your comment about the gut punch. It 100% is, and it will make you think, well, maybe I shouldn't invest that time because, man, that seems like such a waste. It's the exact opposite response that you should have. It should make you press in more to the mentoring and more to the teaching and more to the learning and engagement. Over the years, I've developed a kind of a policy or a philosophy of getting them involved in their own mentorship and getting them involved in the teaching each other.
That's
And
great.
so we have weekly meetings, and people are responsible for topics. This week I was responsible for it, but I haven't been responsible for it in about 3 months. They bring a topic in, they talk to each other, they learn from each other's experiences, they try to develop approaches, answers to those questions, where I'm starting to teach them how to answer each other's questions instead of having to come to me all the time.
Yeah.
And that it's kind of like giving them a fish or teaching them to fish, right?
Yeah.
It's difference. And so having them involved in the process, I feel, has been a huge help for our retention, because they feel engaged. They feel heard. They feel like they are part of the solution. They're involved in it and want to continue to be part of it.
That's awesome. Final question. I think this is interesting too. Um, I've seen your style over the years, and you just mentioned it about 20 minutes ago. You said you had a good relationship with the plaintiff attorney. You seem to have a philosophy, which I want to hear about. And I know that you deal with very difficult plaintiff attorneys, and you seem to, even with the most difficult plaintiff attorneys, you seem to be able to get on their good side and be able to communicate with them and be rational with them more so than other defense attorneys. And we've talked about, more specific. We won't mention names, but those that other people just cannot get along with. You seem to be able to get along with that. Can you talk a little bit about that philosophy and how that's a good thing and a helpful thing when you're working up your case? That really, even though they're your adversary, they don't necessarily have to be the enemy. And you're probably, if they are the enemy and you're treating each other as enemy, you're probably not going to be able to logically talk or come to any resolutions, and it's just going to be a pissing match the whole way, which that may not be the best thing for your client, right?
Yeah, I think there's a couple of comments I'll make on that. One, the philosophy is easy for me to follow just because I feel like that's just generally my approach, my personality. And so I will say, you should learn from others and learn to emulate others that you feel like you can follow. Everybody has their own approach. And so if you try to just imitate someone else's approach that doesn't comport with your personality or doesn't comport with your style, the jury will see that too, and opposing counsel will see that. And it doesn't necessarily work just to say, like, here's the template and here's how you go do it. You have to figure out what works best, what's most genuine for you. I think two things that help me in that world. One, I always try to keep the client interest as the focus. It's not me. It's not about me. I try not to take it personally. Sometimes I do, but I don't lash out or get angry or get upset very often because I'm trying to think this isn't about me. It's not an ego thing for me. This is what's best for the client. The other thing is these cases, like this case we tried for 3 years. I mean, that's a long time to be involved with someone
Yeah.
exchanging emails on a weekly, monthly, yearly basis. You get to know those people on a personal level, or you can just go scorched earth and, dread when the emails come in and not want to deal with it or try to avoid it or do something like that. That to me is no way to practice when we're involved in these cases and we're kind of involved, tied at the hip and communicating for the next 2 or 3 years. It's got to be enjoyable to have that communication. We can disagree.
Yeah.
We can disagree all day and we can go fight for our client's interests and we can have knockdown drag out. And at the end of the day, still be congenial and be nice to each other. And that makes practicing law a lot more fun for me, and just a lot more enjoyable.
It's probably better for your health too.
It's got to be. I mean, it has to be because I've been around lawyers that get wound up on the drop of a hat or every email that comes across, and I'm just like, man, I can't do that. Your blood pressure is probably through the roof, and that's just not good for you.
Yeah. Well, speaking of lashing out and pure anger, there's one situation that I've seen you completely that way. Let's talk about Baylor football. We have college football will be upon us here. It's under 100 days until opening kickoff. Just got spring practices done, portal windows closed. So you got 12-game season coming up. What's the story on Baylor football and are they 9-3? They 8-4? They 12-0? What are the thoughts? What are the rumblings coming out of Baylor?
Expectations are high. Sawyer Robertson's obviously back. He played really well last year. This will be his second year under the offensive coordinator, running more of a spread as opposed to that power zone offense that they were running. Aranda always has strong defenses, and they've loaded up on the defensive side. I mean, expectations are high. As as a Baylor alum and a Baylor fan, I'm hesitant to go any further than expectations are high.
I unfortunately know exactly how you feel. Well, thanks, Shane. Thanks so much. You're always welcome on the podcast, and you and I keep in touch pretty regularly. So we'll keep doing that. To our audience, thank you very much for listening to the Litigation Psychology Podcast. Please make sure, if you're listening on Spotify or Apple or whatever, iHeartRadio, whatever they have out there, YouTube, give us a review. Give us a rating. We'd appreciate that. Again, Litigation Psychology Podcast brought to you by Courtroom Sciences. I'm Dr. Bill Kanasky. We will see you next time.